How y'all doing? Daniel Gaines here. Uh, uh, I'm back because if y'all watched the video, you seen that, as I had already stated a video prior to the court hearing today, and as I stated in multiple of my court filings, I would be ruled against, and this would go to a revision and then to the appellate courts. Well, exactly what I said happened. The dumb bitch did exactly what I said she was going to do. And dumb bitch, I'm referring to the commissioner, not Juliet on this one. The commissioner did exactly what I said she was going to do. So I'm doing my revision now. All I have to do now is put in the case law. I didn't add that yet because it's going to be probably 20 pages or more of just case law. So I figured instead of wasting y'all's time with case law that is already included, I just add that in after I showed y'all the revision filing. The reason I'm using the same case law is because, again, it's a revision. There will be some new case law cited on the record during the revision hearing. Yes, that hearing video and or audio, whichever it is, will be posted to YouTube. I don't give a fuck if they tell me I can or can't, clearly, because you see in the video today she told me not to, and I still did anyway, because they don't have the legal authority to stop you. If you paid attention, you heard to the video, you heard where she started saying I couldn't record, although she can't really stop me anyway, blah, blah, blah. But then I started citing all kinds of shit, and that was the end of it. She didn't bring it up again. She didn't make any more issue of it or anything else. Just like the rest of them do, she had to shut her fucking mouth because she knew damn well she was beat and couldn't do shit about it and has to allow it, whether she likes it or not. So, but anyway, the case law I'm going to add, like I said, I'm going to add after I go over this, and a lot of it's going to be the same. Some of it'll be new on the record. Sorry, I got a hair or something, feels like in my eye. I got a fan on because I'm sitting in my garage. It's not the first time I've been out here, y'all. I'm familiar with that. But, it's late, kids are asleep, so I sit out in the garage. Anyway, I digress. On the record at the revision hearing, I will cite some things that's not in the filing, but then in my appeal, in your appellate brief, the case file goes up to the appellate courts as well. So everything that I filed will be at the appellate court, and then with the appellate brief, you're only allowed so many additional pages for additional information. Excuse me, because I've already gotten all the proof I need on the record. Every bit of the proof I need on the record, because all the proof that's needed for the child support issue, which is what I'm going to appeal, just because it's the only venue they'll allow me to use. So with the extra room in my appellate brief, the little bit of extra room I have, it is completely going to nothing but case law, and I'm going to condense it as much as possible, the citations from the case law that I'll be using, that way I can get as much as possible into the limited space that an appellate brief allows you for new information. It really is very limited, so you don't want to screw yourself to where you have to put everything in your appellate brief, because that's just an impossibility. That's why you want to get as much as you can on the record. That's why my filings have so much case law, legal code, and everything else in them. That way, it's open and shut for the appellate courts. They ain't even got to fucking look past the first 3 or 4 pages of one of my filings and be like, yeah, what the fuck are these courts doing? And ultimately, that's basically what's going to happen. Anyway, I'm not taking this, if the appellate courts happen for some ungodly reason to decide I am special and overturn all their existing fucking case law over my case, I'm not taking it to the state Supreme Court. The state appellate courts will be the final courts in the state of Washington I deal with. This is the final venue. I needed them to deny me before opening me up for the federal courts. The only reason I've been, again, dealing with these fucking corrupt-ass state courts is because if I exhaust all my venues there, it's going to be that much harder for the state to get this matter dismissed or kicked from the federal courts. They're already going to try for a bunch of different bullshit reasons that are going to be unsuccessful, because on the record and on its face, There's all kinds of legal issues that they're obligated to address and have failed to do so. But anyway, enough of the bullshit. Let's get to the... So, as you see, case number, all legit. You can look it up. Go online, Pierce County, Washington, as you see. I'm not going to read through all this shit. But the facts and the arguments, I am going to read. So, let's get into it. During the hearing on Tuesday the 24th, which was today, Commissioner Cook made a number of errors regarding the law. Hold on, I'm taking a drag. When I pause, it'll be because I'm an idiot and I smoke, so I'll be taking drags on my cigarettes. Again, if you're watching this, don't smoke. It's stupid. Don't ever fucking do it. Don't ever start. It's fucking dumb. If you do smoke, you'd be very wise and smart to quit and take better care of your health and body. Full disclosure. I'm an idiot for smoking, and I will not argue anyone calling me an idiot for smoking. I'll agree with you, and sincerely agree. But anyway, back to it. Commissioner Cook seemed unable to tell the difference between the meaning of words, which led to not only her ruling against standing case precedent, but also to the further deprivation of the rights of Mr. Gaines. Commissioner Cook failed to address the lack of evidence that exists on the record, as well as the deficient proof of service. Further, the Commissioner confused the meaning of two vital words that the entire matter hangs on: void and voidable. This resulted in the Commissioner ruling in error, and the courts to once again fail to not only address the errors that exist on the record, but also to correct those errors. And it's difficult to go into much. It's because the order on the filing anyway, in the filing, because the order just says I'm denied. It doesn't give a reason for the denial. It doesn't give anything. It just says that the order was denied. Literally, that's all it says. It technically, the copy of the order I have doesn't even have a commissioner's signature on it. However, the clerk's minute entry, if you go into the case and actually look, the clerk's minute entry said the courts basically agreed with and signed the order, even though there's not a signature on it. So the clerk's minute entry is actually evidence that I file into the case because of what it states. So I don't have to wait for the actual order to be uploaded into the system with the signature on it, thanks to the clerk's minute entry. I'm going to put out my cigarette here before we get into the argument, because this is where, this is where it gets good. As you people know, if you watch my videos, I'm a bit of an ass. I have every legal right to be. Legally and lawfully, I owe them zero respect. I do not have to show any kind of courtesy or respect to the judge, the attorneys, or anybody else. Obviously, you can't engage in any kind of criminal conduct or misbehavior or anything like that. But you do not have to show them any respect if they are violating your rights. There is sufficient U.S. Supreme Court case law to support this. And again, that will be one of the, there's several cases. Actually, there's 9 key cases that I'm going to cite regarding that. 3 from the U.S. Supreme Court, the rest from the either federal district or federal appellate courts regarding that with my appeal. But not until then. For reasons that, if they're not evident, then you'll see whenever I get the appeal uploaded to YouTube, the document for the appeal and everything uploaded and all that. Will be at a later date. But let's get to the fun stuff. During the hearing today, Commissioner Cook made a number of errors in denying my motion, starting with ignoring well-established case precedent in the state of Washington. The precedent was filed with the courts as one of the several filings I made into the matter, which Exhibit A and B respectively. The fact that case law was included into the matter via filing and the commissioner on the record stating she read my filings extensively would lead a reasonable person to believe the commissioner feels she has more authority than both the state appellate courts and the state Supreme Court. Sorry, excuse me. In ruling the way she did, Commissioner Cook once again caused the deprivation of rights of Mr. Gaines. This has been an ongoing issue at the hands of the judiciary in the state of Washington. The appellate courts in the state have ruled and upheld relief from void orders is not discretionary matter. In other words, it's mandatory. Yet even when presented with direct evidence, the courts not only refuse but fail to even cite legal reasons to justify their actions and conduct. What's worse, Mr. Gaines is extremely well aware of the fact that this judge will refuse to comply with the law as well, which is why the entire purpose of this is to end up at the appellate courts. As to a reasonable person, it would appear that this is the level needed in the state of Washington to be an incompetent court. In this matter, as stated on the... In this matter, as stated on the record and in the filings, Mr. Gaines cites over 250 pieces of case law and more than 50 legal codes, while the other side and the courts are unable to cite anything against the evidence presented. Instead, the courts resort to jumping at any chance to use any excuse to ignore the law, even if it means engaging in fraud upon the court. As this court should notice, based on Exhibit A, not a single reason, let alone a legal reason, has been given. What's worse, even after raising the issue of the conduct of Mr. Downing on the record for the at least seventh time, the commissioner allowed Mr. Downing to write up the order, ignoring the proposed order I filed, claiming it wasn't there, in which it was Mr. Downing who failed to put a reason for the denial, and the commissioner allowed this type of conduct. The clerk's minute entry also states that court was long due to Mr. Gaines causing issues. I find it shocking that a respondent who is standing up for his rights and the rule of law would be deemed an issue, when in fact a reasonable person, which is the standard, would find that a respondent having to fight to this extreme for the law to be upheld and followed by the courts is the real issue, especially in a state where fathers, which is the respondent in this matter, only get fair and equal access to their children and a reasonable child support order 7% of the time in the state of Washington. Y'all can look up these numbers. Seriously, you can look up this information. Please do so. You'll see that number is actually factually correct. It's legit. Fathers are only treated fairly 7% of the time in the state of Washington, according to the statistics. Anyway, Washington State is by far the worst state in the nation when it comes to the family law courts. These courts act without jurisdiction and absent all due process when it comes to fathers, yet fail to show the same treatment towards mothers in the same courts. These courts refuse to look at evidence filed by a father, all while allowing a mother to make a claim absent any evidence, and her claim is what the courts base all decisions on. The extreme bias and discrimination based on sex exhibited today by Commissioner Cook is astounding. Court order lacking reason aside, during the proceedings, the commissioner stated she denied the motion to modify based on the fact that I did not file any financial documents with my motion. This one statement alone triples the legal requirements to prove discrimination based on sex, as well as the bias Mr. Gaines has faced in these courts. On the record, in the original filings made by Ms. Parker, then Mrs. Gaines, when she filed for child support, she filed without any financial documentation whatsoever. Yet the courts not only allowed her to file, but granted a default order absent any proof at all. Again, y'all can look in the record. Y'all have the case number. I'll show the case number again. And you can see that everything I'm saying here is factually correct, and it exists on the record that what I'm saying is correct. Anybody, I beg you, fact check me. Prove me wrong. I'll wait. Anyway, yet the courts not only allowed her to file, but granted a default order absent any proof. Further, the entire matter was done with a complete lack of jurisdiction, which makes any and all orders void. The commissioner made another vital mistake in her ruling as well. She stated, I'm not saying these orders are not voidable, I'm saying they're not void. The issue here is Washington State appellate courts have ruled and upheld repeatedly that orders derived from a complete lack of jurisdiction are not voidable, but void. The commissioner is either too stupid and incompetent to know and understand the difference, or she, with intent, conflicted the meanings to avoid addressing the serious legal issues that exist on the record. Yeah, that's right. I put a commissioner as basically a judge is too stupid to understand. Because that's, well, it's factual. One of the two is true. It can't be anything else. Anyway, let's keep going. Black's Law Dictionary defines them as void, an adjective, of no legal effect, null. The distinction between void and voidable is often of great practical importance. Whenever technical accuracy is required, void can be properly applied only to those provisions that are of no effect whatsoever, those that are an absolute nullity. It defines voidable, an adjective, valid until annulled, especially of a contract, capable of being affirmed or rejected at the option of one of the parties. This term describes a valid act that may be voided rather than an invalid act that may be ratified. Now, the issue is the state Supreme Court, or appellate courts and Supreme Court, although it's limited at the Supreme Court level because most of this is at the appellate courts, states that they're not voidable, they're void. So they're not voidable, which means valid until annulled. They're not voidable, they're just void of no legal effect. But anyway, let's continue. The distinction between them comes in the appellate court's own standing case law and case precedent, which clearly states a complete lack of jurisdiction. The resulting orders are not voidable, but void. Based on this one point alone, this court should find error in the commissioner's rulings. However, when added with the complete lack of jurisdiction resulting in the complete lack of due process, this court has a legal obligation to remedy the issue. And then I just put that there because, well, just as a placeholder, not that I need to, I know where it goes, but that's where I'll insert the case law. Like I said, it's going to be roughly around 15, 20 pages, maybe even 20, 25 pages, but there's a lot of it. Standards of review, I'm not going to read, but the conclusion I will. Commissioner Cook erred in denying the motion to modify on the grounds the entire matter is void. The commissioner failed to uphold and comply with the law, as well as failed to comply with standing case precedents. The extreme bias and discrimination based on sex by these courts is shocking and should not be allowed to stand. Mr. Gaines is asking this court to finally administer the justice this case has been lacking since its start. However, since Mr. Gaines is well aware of the fact that this judge will also ignore the law and case precedent, the entire purpose of this is to establish an extremely clear record of the bias for the appeal that will be filed when this judge violates the law. The purpose of the appeal is to strengthen the federal lawsuit that will come after the appeal is filed now that the final venue has been denied to Mr. Gaines. Yeah, I have balls, as y'all should be aware, and I put this shit in writing. I let them know exactly what the fuck I am setting these stupid fucks up for. And the funny part is, these stupid fucks know it's a setup, know they don't have a chance in hell at the appellate level, and they still fall for it every time. Anyway, let's finish it up. It is astounding how the standards are polar opposites in the state of Washington when it comes to mothers and fathers. The 14th Amendment requires fair and equal protection under the law. Yet on the record today, the commissioner confirmed what all fathers know to be fact. There is clear bias and discrimination based on sex. Again, this was more than proven when the commissioner denied my motion on the grounds of no financial information being filed, while allowing the record to reflect Miss Parker was allowed to file and be illegally granted child support without any financial information of any kind. And for now, it's only 7 of 7 pages, but as you see, the 7th page is pretty much empty. But that will change because of the fact that case law is still going to be added in there and everything else. And like I said, with all that case law, it's going to be anywhere from 15 to 25 pages. I mean, I'll put it to you like this. I'm mostly copying and pasting. There's only a small handful of cases that I'll actually have to type out. Most of them are already in my other filings. As I said, I'm only adding a few that aren't already included. But one filing alone, it's the one that I showed that I actually sent to Juliet. It's, what is it? I think 12 or 13, maybe more pages of just case law alone in that one filing. And there's, let's see, 6, maybe 7 filings I made in this one matter. Oh yeah, it's like that. I file. When I file. And the beauty of it is, when I file, a lot of times it's in response to their filings. I file direct evidence. I file valid and standing case law. I file valid legal code. I'm thorough. I do the damn thing. I've been forced into this for a lot of years. As you can see, even when they rule against me, it's not a loss. It can't be deemed as a loss because they're unable to cite legal reason, and legal reason is actually required that for them to cite. They're actually supposed to cite legal reason for their rulings and evidence and blah, blah, blah. They're unable to cite anything. They're unable to tell me I'm wrong. They can't get around the evidence I filed. They can't get around the case law I cite. They can't get around the precedent. They can't get around the legal codes. They can't get around none of it. But yet they jump on things like a bitch in heat, any excuse they can to avoid the legal issues. Even when they're not allowed to do so, as y'all seen from the hearing today, they do it anyway. So, it's extreme corruption. It's extreme bias and discrimination based on sex. If you have a penis, you are automatically deemed the bad guy and unfit, regardless of anything else, any other facts, evidence, or what have you. It's a corrupt, disease-riddled temple that needs to be destroyed in its entirety. And I've been asked, why don't you file certain or cite certain things? Why don't you go ahead and just file at the federal level now instead of playing these games and blah, blah, blah? And I'll be candid with you. I'll be direct because, well, I'm a straight up and direct person. The reason, so it's clear, even for the fucking commies in the state of Washington who are monitoring my YouTube and everything else, trying to find what they can use against me or to know what, if they to give them a heads up on laws they can try and research or anything else, and they still can't get anywhere. But anyway, for their benefit too, it ain't gonna help them. But the reason I haven't elevated this to the federal system yet is because the more of these venues in the state I attempt, the more members of the judiciary in Pierce County I get to get in front of. The more members of the judiciary in Pierce County I can get in front of, the more members of the judiciary in the state of Washington that are acting with a complete lack of jurisdiction, acting outside the law, violating due process, protected rights, and everything else. Which means each one of them that does this, they're essentially waiving their 11th Amendment judicial immunity. And the only way you can sue a judge is you have to be able to get around their judicial immunity. Now, to be able to do that, it's extremely complicated. And the bar is insanely high to be able to get around 11th Amendment judicial immunity. Which, to an extent, I agree with. Judges shouldn't be allowed to be sued because somebody's feelings are hurt. So to an extent, I agree that bar should be high. There should be oversight of judges. Judges should be accountable for their conduct and everything. But the bar to sue them should be high, which it is. However, one of the ways around it is a judge acting in a complete lack of jurisdiction, which is a lack of subject matter and personal jurisdiction. And another way is a judge knowingly acting in violation of the law or in violation of constitutionally protected rights. You have the burden of proof to establish these things clearly on the record before the lawsuit will even be allowed to go forward. So in your initial filings, if you don't clearly establish that these things took place, the lawsuit, at least where the judges or members of the judiciary is applied, will be kicked, and you'll either have to move forward without those names on your filing, or you'll have to refile and remove those names. That'll be up to the courts to decide, but they'll have to articulate which they want you to do, and it'll go from there. once things are adjusted or changed or however it needs to be done. But for me, because there is a complete lack of jurisdiction, all I have to do is bring up the jurisdictional challenges at any point during the proceedings, and if they fail to address it, then that's them also engaging or making a ruling with a complete lack of jurisdiction, because everything we're dealing with is from 2004 or derived from the orders that came from a complete lack of jurisdiction, which means everybody who touches this is waiving their judicial immunity, which means they're opening all themselves up to a lawsuit. So the goal is, in part, is to bring a lawsuit against as many members of the judiciary as possible whenever I bring this lawsuit against the state, because they're all getting named together. That's how a lawsuit against the state works. You name the judges, the state, the governor, the attorney general, everybody involved, blah, blah, blah. Even the court clerks, all of them, whoever you can name, you name. That's how you do it. Federal lawsuits are usually going to have 40, 50, 60, 70 or more names to them. Mine's no different, no exception. But anyway, the purpose is to get as many of these corrupt actors removed as possible in one action. So that means if I can literally get every single judge in Pierce County, Washington, removed from the bench for criminal conduct, placed under criminal investigation, and possibly thrown in jail, then that's what I feel I have an obligation to other fathers to do. If that means that fathers in Pierce County have to wait several more months for their matters to be heard because they have to replace every judge, then that's good. Not that they'll have to wait. That's the bad part. But the good part is, whenever the wait's over and they actually get their day in court, they'll have fair treatment because, well, Pierce County is going to be watched because of the extreme conduct of all these different members of the judiciary, including the longest sitting judge in Pierce County, Gerald Johnson. Again, fact check me. I'm begging you. Please fact check me on this. Look into the things I'm saying. Google Scholar is a good place to look this stuff up, to look up case precedent and stuff like that. Justia Law is another good place. Cornell University is another good place to get legal information from. Hell, you can even look up federal codes. It's United States Code. 18 is criminal, 28 is civil. You also got 42, which is civil. There's a lot of different codes, but it's USC, United States Code. Check into anything I'm saying, fact check anything you wish. Prove me wrong. I'm begging you. I'm begging anyone to prove me wrong. Hell, it may even come to the point to where I offer a cash reward for somebody if they can prove me wrong. No, it's not to that point yet, because I've got other things I got to take care of financially first. But then, what is it? Maybe a month away, whenever I have all those expenses covered, I might actually put a couple $100 reward up to somebody who can actually prove me wrong on any of the claims I've made in these courts. Now, to prove me wrong, you got to have sufficient case law, more recent than what I use, and you have to have the case law that overturns the case law I use. Good luck, because it doesn't exist. Because unlike these judges, I actually stay current on things. And this isn't a knock to anybody who watches this that's not a part of the courts. This is more so a knock to the clowns that are associated with the courts, the friends of the courts, the court actors, the state actors, the government actors, and stuff like that who are watching this. They know who they are. DCYF, probably a couple of the clerks, probably a judge or two. I don't know about the judge, but I know DCYF and them are watching still. But anyway, it's likely going to come down to, I'll put a cash reward out for somebody who can prove me wrong. If I do anything like that, it might be something like that. But again, I don't know, and I'm not doing it at this time. I would like for somebody to prove me wrong, though. I would like for y'all to fact check me, because see, if y'all fact check me, y'all are learning too. And that's what we need, is more fathers, more parents to be educated on parental rights. Because the more parents who are educated on parental rights, the more parents who will can or will file legal action, and the more likely it is that laws will change. Because, see, it still comes down to the damages I'm seeking in this, which the dollar amount keeps going up every fucking court hearing. But the damages I'm seeking in all this, outside of Stephen Downing, Miles Russell, Jarrell Sanders, Carolyn Merling, Juliet and her father, the damages that the state is guilty for, are liable for the deprivation of rights, the punitive side of that anyway, the punitive side of the damages I'm entitled to for the extreme deprivation of rights, conspiracy against rights, the RICO violations and everything else, I'll let it go for $1, provided the state changes their laws to 50-50 equal shared parenting, with the default of needing sufficient cause for child support with 50-50. Now, it's fit parents. However, in order to deem a parent unfit, they actually must comply with due process, and the standard, the evidentiary standard, must be met, because that's part of the issue. But anyway, that's a half hour, a little over a half hour of your time wasted. Hope you all enjoyed how much of an asshole I can be in my filings. Love y'all. Have a good one. Peace.